This is Barry Zalma speaking for Claim School Incorporated's blog, Zalma on Insurance. Today we're going to speak about why an indictment establishes probable cause where an insurance fraudster sued for malicious prosecution, only to find that a malicious prosecution suit requires a favorable termination of the prosecution, not just the prosecutor deciding to do nothing and fail to go forward with the trial, proving us always that no good deed goes unpunished. Mrs. Marty Spann alleged that Defendants Asurion Insurance Services, Inc. and former District Attorney General Bruce Griffey and Tennessee Wildlife Resource Agency employees Ed Carter, Mitchell Bailey, Dale Grandstaff, Brad Jackson, and Shawn Karns, collectively the state defendants, maliciously prosecuted her for evidence tampering and insurance fraud. The court was faced with two motions to dismiss filed by the State Defendants and Asurion. In Marty Spann v. Ed Carter et al., the United States District Court for the Middle District of Tennessee on May 17, 2024, resolved the issue of malicious prosecution against an insurer and the state. Although the operative amended complaint reads like a potential blockbuster movie, the court only needed to recite a few allegations to resolve the pending motions. That is, on February 21, 2014, Mrs. Spann was arrested and charged with tampering with her husband's cell phone, which she allegedly knew was potential evidence in an investigation, and filing a false insurance claim with Asurion reporting the cell phone was missing. On September 13, 2022, many years after her arrest, more than 8 years after the arrest, the state of Tennessee dismissed the charges against Mrs. Spann under Tennessee Rule of Civil Criminal Procedure 48A. Mrs. Spann then brought this lawsuit against the State Defendants and Asurion for malicious prosecution, alleging that each defendant played a role in bringing the baseless action against her to begin with and continuing to prosecute the action without probable cause. Asurion and the State Defendants moved to dismiss the amended complaint for failure to state a claim under Federal Rule of Civil Procedure, Section 12b-6. Malicious prosecution under Tennessee law requires the following. 1. A prior suit or judicial proceeding was instituted without probable cause. 2. The defendant brought such prior action with malice. And 3. The prior action was finally terminated in plaintiff's failure. The State Defendants and Asurion argued that Mrs. Spann's state malicious prosecution claim failed under the third element because the criminal proceeding at issue did not terminate in her favor. They based the argument on the fact that Tennessee Supreme Court recently clarified that for purposes of malicious prosecution, an action is terminated in plaintiff's favor only if the termination of the underlying criminal proceeding reflects on the merits of the case and was due to the innocence of the accused. There is no language in the order or Rule 48A that reflects on the merits of the case or indicates that the case was terminated due to Mrs. Spann's innocence. Accordingly, the court dismissed Mrs. Spann's state malicious prosecution claim because she did not allege facts sufficient to show that the dismissal of her criminal charges constituted a favorable termination. They just failed to try her. Malicious prosecution is different under federal law. The federal claim, 48 U.S.C. Section 1983, provides that an individual may bring a private cause of action against anyone who, under color of state law, deprives a person of rights, privileges, or immunities secured by the Constitution or conferred by federal statute. To successfully bring a Section 1983 malicious prosecution claim under the Fourth Amendment, a plaintiff must plausibly argue and allege 4 elements. 1. The defendant made, influenced, or participated in the decision to prosecute the plaintiff. 2. There was no probable cause for the prosecution. 3. As a consequence of the legal proceedings, the plaintiff suffered a deprivation of liberty apart from the initial arrest. And 4. The criminal proceeding was resolved in the plaintiff's failure. Because the September 13, 2022 order of dismissal establishes that Mrs. Spann's criminal prosecution ended without a conviction, she has plausibly alleged that the criminal proceeding was resolved in her favor, although the complaint does not specify or indicate how Asurion, a private insurance company, acted with state-given authority. Conclusory allegations are insufficient to show that Asurion is a state actor. Accordingly, the court dismissed Mrs. Spann's federal malicious prosecution claim against Asurion because the complaint failed to allege Asurion acted under color of state law. The grand jury indictment provides a presumption of probable cause for Mrs. Spann's prosecution and defeats the claim of malicious prosecution. Mrs. Spann has not come close to rebutting the probable cause presumption because she has not alleged that any state defendant provided false testimony to the grand jury to secure an indictment. Accordingly, the court also dismissed Mrs. Spann's remaining federal malicious prosecution claims for failing to rebut the probable cause presumption created by the grand jury indictment. In my opinion, Mrs. Spann was arrested based on probable cause on 2 crimes, including the crime of insurance fraud. The basis of the claim was the dismissal of the prosecution without a finding of fact, a trial, or an acquittal. The state just decided they did not want to try Mrs. Spann for the crime after waiting many years. Providing that no good deed goes unpunished, Mrs. Spann took the dismissal and decided to try to profit from the good deed of dismissing her criminal prosecution. Her attempt failed because there was no evidence of malicious prosecution. This video was adapted from my blog, Zelma on Insurance, which is available free to anyone who clicks on the URL zelma.com/blog. You can subscribe to the blog and you'll receive notice of every blog posting, usually 5 or 6 a week, and you will gain access to the more than 4,800 blog postings. You can also subscribe for free to the videos on YouTube and or rumble.com, and if you do, I'd appreciate it if you click on the like button on YouTube or the thumbs up button on rumble.com. And if you're interested in obtaining further detail about insurance, insurance claims, insurance fraud, and insurance law, please consider, for a very small fee, subscribing to my Substack publication. Thank you for your attention.